Be ready. 5 seconds.
We have perused the evidence of the prosecution witnesses and the statement of the accused under Section 313 of the CRPC. Stop. From the statement and the evidence on record, it becomes an admitted position that the age of the victim on the date of the incident was 14 years, and the age of the accused was about 25 years. Stop. When the statement of the accused was recorded, the age of the victim's daughter was about 10 months. Stop para. The evidence of the victim reveals that she also claimed that she married the accused. Stop. She stated in the cross-examination that she left her house of her own will and married the accused. Stop. The first informant, the victim's mother, deposed that the victim was 14 years old. Stop. She produced the victim's birth certificate in the evidence. Stop para. We are not referring to the medical evidence as it is an admitted position that the accused kept physical relations with the victim. Stop. There is no dispute that the accused is the biological father of the child. Stop. There is no explanation for the gross delay in investigation and the delay in arresting the accused. Stop. As stated earlier, the accused was arrested and later on, was enlarged on bail. Stop para. When a court deals with an appeal against an order of conviction, the judgment must contain a concise statement of the facts of the case, the nature of the evidence adduced by the prosecution and the defense, if any, the submissions made by the parties, the analysis based on the reappreciation of evidence, and the reasons for either confirming the guilt of the accused or for acquitting the accused. Stop. The appellate court must scan through the evidence, both oral and documentary, and reappreciate it. Stop. After that, the appellate court must record reasons for either accepting the evidence of the prosecution or for disbelieving the evidence of the prosecution. Stop. The court must record reasons for deciding whether the charges against the accused have been proved. Stop. In a given case, if the conviction is confirmed, the court will have to deal with the legality of the sentence. Stop. In such a case, there must be a finding recorded on the legality of the sentence with reasons. Stop. The ultimate object of writing a judgment is to ensure that the parties before the court know why the case is decided in their favor or against them. Stop. Therefore, judgment must be in a simple language. Stop. The conclusions recorded by the court in the judgment on legal or factual issues must be supported by cogent reasons. Stop para. No doubt, the court can always comment upon the conduct of the parties. Stop. However, the findings regarding the conduct of the parties must be confined only to such conduct which has a bearing on the decision making. Stop. A judgment of the court cannot contain the judge's personal opinions on various subjects. Stop. Similarly, advisory jurisdiction cannot be exercised by the court. Stop. The judge has to decide a case and not preach. Stop. The judgment cannot contain irrelevant and unnecessary material. Stop. A judgment must be in simple language and should not be verbose. Stop. Brevity is the hallmark of quality judgment. Stop. We must remember that judgment is neither a thesis nor a piece of literature. Stop. However, we find that the impugned judgment contains personal opinion of the judge's advice to the younger generation and advice to the legislature. Stop.